Okay, well let's get started, and welcome to everybody this morning, and welcome to this webinar. Today we are going to cover some various updates on the COVID-19 statements which have come out from the government, and then I'm going to hand over to Mr. Darren McGuinness from Harold Stock and Co, who's going to give us an update on certain aspects we should be considering when we're looking at our personal position and our private lives and our business position. So, first of all, the portal for furlough claims went live on Monday, and the government updated the guidance actually on Friday night, which didn't help, but it showed that other items could be included. So, for instance, non-discretionary overtime, non-discretionary fees, commission payments and piece rate payments. But anything that's not basically stuff that cannot be claimed is discretionary items and so on, non-monetary benefits. So that sort of stuff came out in the furlough claims update as well. But then also to throw us, they actually started to work out the calculations on calendar days rather than working days. So that also threw a spanner in the works as well, as did the question of how to work out the employer's national insurance and pension pro-rating. So again, we had to deal with those issues, hence the reason why it takes so long to actually work out the calculations on this. A couple of other practical points which have come out on these claims as well is the service actually times out after 15 minutes and not 30 minutes as they previously advised. So you need to be fairly quick on this. And you're also asked to submit various references, so UTR numbers, CT references, company's house references, which you may or may not have to hand. And if you have less than 100 employees, you've got to key in data at the employee level. So it can be hugely burdensome for weekly payrolls. If you're reporting for over 100 people, then you can just upload a file. But basically, if you've got 99 employees and you make a mistake, you've actually got to start all over again. Not very helpful, but anyway. So those are the sorts of issues we've been having to deal with. The service did crash a couple of times early on, but generally it has been running very well. And you know, you have to give some credit to HMRC on actually making sure that this does work, and it has worked reasonably well. There have been a few differences in how the calculator has worked out calculations, and we've had to work out why there are differences between the two. But generally things have been, overall have been running fairly smoothly. We are working at Harts, we are working through the claims. We've got quite an awful lot to do, and we are getting through them as quickly as we possibly can. One thing which has caused a lot of confusion is that people think they've got to make the claim by yesterday to get your money in. It's not. You can make your claim at any point. It's just that if you wanted to make your claim by yesterday to have the money with you by the end of the month, then that was the only deadline. If you're going to be short for a day or two, it just means the claim will come in, the payment will come in after the 30th of April. They will pay you within 6 working days, so just bear that in mind as well. But there is no restriction on the claim, so if you haven't, you don't feel like you've missed out if you haven't made the claim just yet. It just means you'll get paid out a day or two later. And moving swiftly on to the self-employment scheme, an update was issued a couple of days ago. And basically HMRC said the previous update shouldn't have been released, but this one has. And the online service used to make a claim isn't yet available, and HMRC will aim to contact the relevant self-employed people by mid-May, and will make payments by early June. So we just need to watch this space on that one. And the final point I want to make is those businesses that are effectively publicly funded. So this can cover nurseries, care homes, residential homes. If you're funded by your local authority or you send out invoices to your local authority, you're not going to be able to furlough your staff. They expect you not to be furloughing people which are funded by the local authority. So that is something to bear in mind. Now, it may well be that you're partly funded by the local authority, i.e. you get parental contributions as well. If that's the case, please get in touch with us and we'll tell you how to work out the claim, or we'll do that for you. So again, if you are publicly funded or you receive income from local authorities, please bear in mind that you should not, they are expecting you not to furlough staff. That's really the quick update of what we've got so far. Not a lot else has changed. At this point, I'd like to hand over to Mr. Darren McGuinness of Harold Stock & Co. Harold Stock cover all areas of the law, including looking at business protection, which is wills, powers of attorney. They also cover personal injury, medical negligence, family matters, and they operate from 3 offices around Manchester in Stockport, Failsworth and Moseley. So they have a lot of experience in dealing with this area. So at this point, if all works well, I'm going to make Darren the presenter, and basically over to you, Darren.
Okay, thank you. I'll see if this works. So just share my screen. Is it there? There it is. Okay. There we go.
Nearly there.
Okay, good morning, everybody. Darren McGuinness, Harold Stock & Co Solicitors. Hoping to put a positive slant on COVID-19, if that's at all possible under the present situation we all find ourselves in. So what we're going to look at today is business protection, what we probably should be doing, could be doing, as well as some of the other areas we can deal with, such as lasting powers of attorney, business powers of attorney, and wills. So all things that probably should be on our radar but aren't necessarily at this moment in time. So just picking a couple of things out of the slide there in front of everybody. Limited companies, shareholder agreements. If you haven't got one, you probably should have one. If you haven't got one and you need one, then you should be looking at proxy votes or incapacity clauses that go in there. What if clauses, as we like to call them. The chances are they're more likely to be wanted going forwards now than they have been in the past. Similar clause is added into the director service agreements that could be placed on business protection within the business as well. Disaster recovery plan, yes, some use that was, but again, the benefits of what we've just been through or going through is that we should have a good idea about what does work, what doesn't work, and where we can make changes going forwards that will actually assist the business in making sure that this doesn't impact as heavily as it has done on this occasion. An opportunity really to review and reflect by remodeling or reshaping the business, considering what do you need, what's in the business, is the business going to go in a different direction, or what the attitude to risk is going to be going forwards, as well as embracing the technology that now befalls us on a daily basis. Web conferencing, I didn't think I'd be doing a presentation by web conference at this particular moment in my life, but there we are. Okay, moving on to powers of attorney. These are the ability to pass the control of any of your matters, whether they be personal or in a business capacity, to look after affairs. So those affairs are dealt with in various different ways by your attorney, and you can deal with them and give them power to do what you need them to do in order to keep either your business running or your personal life and your personal affairs in order. We'll start with the basic, the general power of attorney. This only lasts for 12 months, but it is quite a powerful tool, because at this moment in time, if you have capacity, you can make one of these. You can give other people the authority to look after your financial affairs. You can give them the authority to take care of your business, even with just a general power of attorney. The idea being that you can revoke it at any time, and in the short term, it's there and ready to use. the benefit is it doesn't have to be registered. It just has to be signed off and witnessed, and then it can be used straight away. A more common power of attorney is the lasting powers of attorney, which are the ones that everybody talks about these days. These are in two different areas. One is financial, the other is health and welfare, and they deal with everything from dealing with your financial affairs, from property, shares, businesses, etc., right the way through to care homes, what care home you go to, if that would be the case, or even up to the ultimate sanction of having to switch a machine off in the best interests of the person you're looking after. There are a few difficulties at the moment in relation to these, because you have to have a certificate of capacity for these to work. Now, a certificate of capacity is normally signed by a solicitor. It can be signed by a family friend who isn't party to the power of attorney, and this will allow them to, this allows them to clarify that the person making the power is actually of sound mind, or as I prefer to call it, they have all their marbles. We can make sure that these are used in a business sense under the business power of attorney, and there are lots and lots of controls that you can put in on a financial power of attorney to make sure that people can look after your business without running away with it. So they have authority to do what you want them to do, but you can also specify what you don't want them to do. So I've put a few examples on the slide there. Signing checks, authorizing payments, hiring, firing, or even closing or selling a business, which might be the ultimate responsibility for somebody looking after your affairs. Who could you choose? Someone that can run the business. So someone that's capable of running your business, not necessarily a family friend. It could be somebody that's in the business that doesn't have the same financial clout as you, or isn't an owner of the business, but certainly is capable of doing the day-to-day running. But somebody that would follow your instructions if you left them those within the business lasting power of attorney, or an accountant or a solicitor. And you can specify how they're paid within the documentation as well, and you can make sure that these people are able to make your business tick, whether again that is to keep it going or it is to move it towards selling or winding it up, depending upon what's best for the business at the time. Problems caused by COVID-19, assessing capacity. How do we do this? Solicitors generally would sign a capacity certificate within any lasting power of attorney. This is normally done by a face-to-face meeting. This is normally done by discussing various activities that are going on in the world at the time to ensure that the person making the power of attorney is capable of doing so, understands what they're doing, and conforms with the Mental Capacity Act. And at this moment in time, that can be done by Zoom or Facebook Messenger. It can still be done by a friend or neighbour who isn't going to be used within the power of attorney. But these are hard to do when the person that you're talking to could be sat in a room with somebody else, who could be prompting them, who could be feeding them the answers that mean that the assessment isn't really valid. And therein lies the difficulty. The other issue at the moment caused by COVID-19 is that the registration of a lasting power of attorney takes between 8 and 10 weeks at best. Now it is taking longer. The idea is that they are checked, double checked, and then sent out to everybody over a period of time. The difficulty is that the number of staff dealing with these at the Office of Public Guardianship is down, and therefore the waiting time to get them back is likely to be longer. There is also, as I've mentioned before, an ideal time at this moment where people can be unscrupulous in relation to getting their own way, because a lasting power of attorney is exactly that. It is very powerful. It does do what it says on the tin, and you can, without restriction, do a number of things that could cause problems for the donor. At this moment, recommendations from solicitors are that if you want to get a power of attorney done quickly, then opt for the general power of attorney, which is a short form, which can be used straight away and can be given to the person that you wish to have the power, and they will then be able to deal with the affairs of a business or your personal affairs straight away. The benefit, as I've said before, is it can be revoked immediately. As soon as you decide to do so, you file a revocation, and at that point in time, you are back in control. You could couple this up with making an application for a lasting power of attorney at the same time, so that as soon as the lasting power of attorney comes into play, then the general power of attorney can be revoked. The benefit of a lasting power of attorney is that those are registered, those are kept on a central register, and those are looked after by the Office of Public Guardianship, which means that you are then in a much stronger position to make sure that you're being looked after properly. Wills. These are always a contentious issue. They are always something that people get round to doing when they have an event that triggers their views on their own mortality within their lifetime. So normally it's the passing of a friend or a family member, it's winning the lottery. Doesn't happen to us all, certainly don't get more than £10 on these days, but also we have the issues concerning making sure that people are looked after properly with regards to what's going on. So with a will, you need to make sure that people are doing this as quickly as possible if they need them, and people are more and more likely to want one now because of the events that we are going through than they did before. Yes, coronavirus has increased the demand dramatically. People are wanting wills yesterday. Unfortunately, demand is such, and the execution of these is such, that delays inevitably will occur, although solicitors are doing their best to find ways round to make sure that witnessing and executing the will can be done properly. In order to consider what we have to do, just a brief piece of information about what makes a valid will. 1837 is the last time that the Wills Act was dealt with. It's not been updated since. It isn't built for the future, it isn't built for now, but a will has to be in writing, signed by the person making the will, and again a wet signature, not digital, something that may change in the future, but at this moment in time still remains the same. They must have capacity, and the most difficult clause to try and deal with here is being witnessed by two independent people in the presence of the person making the will and in each other's presence. And how do you square that circle against social distancing? There's been some innovative ways of dealing with this: witnessing wills on car bonnets, witnessing wills through a window, over a fence. So on each of those, making sure that social distancing is taking place, a friend or a neighbour who isn't named in the will with another friend or a neighbour is looking at you through the window, or looking at you through a car window, making sure that the will is signed in their presence and then passed to them carefully and sensibly, observing all the relevant social distancing criteria, witnessed by them, handed back, and then returned to the solicitor. This seems to have been working, as well as sending out information in the post to ensure that people are doing this the correct way, so that the witnessing of a will is done properly.
So there have been some very interesting ways, Darren, that people have been doing this, I can imagine, and you've probably seen quite a few. If anybody's got any questions on this so far, by the way, there is the use of the chat box, which is speech bubble in the top right hand corner of your screen. Just type in your question in there. We will be doing questions and answers afterwards. Just in there, if anyone's got any questions on wills, just at the moment. So back to you, Darren.
No problem. Thanks, Stephen. Instructions for wills can be taken over the phone, can be done by face-to-face web conferencing. The only downside to that is, again, we are all pessimistic, undue influence, who else is in the room, who else is prompting the answers, who else is making sure that these things are transmitted to the solicitor on the other end. Normally, it's quite safe to do it, but we always make sure that whoever is in the room is identified, and that the the area is looked at by whoever's on the other end of the web conferencing facility to make sure that they're either alone or we know who's in the room, so a proper record can be taken. The biggest concern, of course, is the will executed properly, because people make wills wanting wills to be dealt with properly, and unfortunately, if they don't deal with them properly, then they're always open to a challenge, and the will's validity can be scrutinized. We will probably see more of this as a result of COVID-19 than we have done before, although there are many cases still going to court about challenging the validity of a will. So, bringing this to a conclusion, what opportunities do we have as a result of COVID-19? I think we have an opportunity certainly to consider getting things done now whilst we have, some of us have the time, looking at what documents we have within our business that would assist us, whether that's insurance, whether that's powers of attorney, shareholders agreements, wills. A review of the business from top to bottom is likely to assist, and certainly everybody is doing that at the moment. They're all everybody's looking at their own businesses and thinking, what can we do? How do we make this better? What do we do to sort it out? My view is try and put your own affairs in order. This will impact your ability to look after the business, because if you know what you want, you know what's best for your business, you can tally the two together, and then you're in a much stronger position going forwards. You can protect your business and plan for problems. You can understand now what we are facing, what we could face in the future, and it's always good to have a contingency plan. It may sound pessimistic, but having plan B, C, D, E, F, however many you want, is something that will assist going forwards. And these are part and parcel of a disaster recovery plan that most businesses should have written down somewhere in the event of an emergency, albeit a global pandemic isn't necessarily something that we all thought would happen. Other smaller, more likely events could happen that are likely to affect the business, and this would make your business more robust. A little pointer for the accountants out there, understand your numbers. If you understand your numbers and understand how much money you've got coming in, when you've got the money coming in, and how much you can afford, you can then keep the business alive and make sure that you're in a much better position to understand where you're going. And I would use this as an opportunity to plan what you're going to change about your business within the next 6 months. Is that more staff, less staff, product base? Can you manage from the premises you're in? Do you wish to change premises? These are things that will likely to occur going forwards, and cause people to review where they are. So hopefully a few pointers there to assist us in getting ourselves out of this mess, but with some more tools in our armory to make us stronger going forwards. Back to you, Stephen.
Great, thank you very much indeed, Darren. That's very informative. I'm just going to change back to myself, and so there we go. So you've got the details of there for the people like myself who are presenting, and for Darren McGuinness from Harold Stock & Co. Has anybody got any questions? I know we have had just one question in the chat box so far, and that's regarding powers of attorney. So if, for example, I pass it to my husband but we both die, is there an ability for a second in line? I think, Darren, that's for you to answer, not me.
Yes, on any lasting powers of attorney, you can have any number of substitutes. We would always recommend that people place substitutes in there. It is usually to the partner and then down, quite similar to what we have with wills. So yes, there is always a contingency for others falling into line as and when the inevitable happens.
Great, thank you. Has anybody got any further questions they want to ask? If you do, just unmute yourself by clicking on your screen and just shout out. We've got a little bit of time left if anybody does have anything else to say. No. Okay. Oh, Ian's got a question. Am I correct? You cannot amend a power of attorney. You have to do a new one. Is that correct?
Yes, you would have to do a new lasting power of attorney. Yes, you would.
Fine. So you have to do a new one. You can't do another one. Great. Before we finish, bear in mind that
I have a question.
Yeah.
Sorry. Going back to furloughing, Simon pulled up some information that said if you were furloughed, you could have nothing to do with working for the business.
Yes.
But I thought I understood you to say as long as it wasn't anything to do with making money for the business. So I thought I could come in and do accounting and things like that.
Yes, if you're director of your own limited company, you can maintain and continue to do your statutory duties. You can't do any income generating work. So that will mean after the accounts, dealing with meetings, that sort of thing.
I'm not a director, company
Okay.
secretary.
Fine. If you're company secretary, you're still an officer of the company. So again, I believe that will also apply to you. That you, as long as you're just doing the accounting work and you're just maintaining the records, I believe that might apply. But if not, I will come back to you.
Yes, please.
Drop the details in the chat box, and I will come back to you because there is a differential between company directors and company secretary. So I will come back to you on that. Anybody else got any questions they want to ask at this stage? Has anyone got any other suggestions for the webinars as well? Because this is the 5th in the series. And rather than going over old ground again, if anyone's got any suggestions that they want to put forward, we'll happily put one on for you. We aim to do one of these a week. This webinar has also been recorded. It's up on our YouTube channel, which is at Harts Limited, limited spelt in full, and along with all the other webinars as well. So we're building up this library of information which is there for you. Please feel free to go back on and have a look at that. The slides are also up there as well as part of the webinar. If nobody else has got any questions, all it remains to me to say is thank you very much for Darren McGuinness at Harold Stock Co, who's given us a good insight into how wills and powers of attorney are needed at this time. And I look forward to seeing you all soon. And please stay safe. Thank you.
Thank you.
Hold on, please. Cheers, Stephen. Thank you.
Thanks a lot. Bye-bye.
Thanks.
Yeah, thank you.